So today I wanted to provide a quiz on the California legislative process. And of course, these are true or false questions. I put together 22 of them on the California legislative process. So question one is an enrolled bill report, an EBR, is prepared only by the California Department of Finance when a bill reaches the governor's desk. And that's false. Actually, relevant state agencies and departments, even the Office of Legislative Counsel, in addition to the Department of Finance, prepares EBRs for bills that reach the governor's desk. Question two, the California Constitution requires the legislature to pass the state budget by midnight on June the 30th, and this is false. The Constitution in Article 4 imposes a June 15th deadline. Question three, the California Constitution requires a 55% vote for passage of the state budget. That's false. It used to be 2/3, but after Proposition 25 was adopted by the voters in California, it is now a majority vote, a simple majority for the under the California Constitution for the two houses of the legislature to pass the state budget. That vote threshold of a majority also applies to any budget bills junior and budget trailer bills that have an appropriation and that are identified in the budget bill. Question four is a bill with an urgency clause requires a 2/3 vote of the membership of each house of the legislature for passage. And that's true. Note that a 2/3 vote is required for both the urgency clause and for the bill in chief. Question five, constitutional amendments require a majority approval of the two houses of the legislature as well as signature by the governor in order to be placed on the statewide ballot. And that is false because the governor does not act on a constitutional amendment. Moreover, constitutional amendments have to pass by 2/3 vote of both the Senate and Assembly in order to reach the statewide ballot for a vote of the electorate. Question six, a committee may pass, hold, or defeat a bill that the committee has before it. And that's true. Those are the three options after a bill has been heard by the committee. Of course, it doesn't have to actually hear the bill. Question seven, engrossing and enrolling of a bill is the same thing, and that's false. So when a bill is amended, the printed form of the bill is proofread by legislative staff to ensure that the amendments were inserted properly. And after being proofread, the bill is deemed to have been correctly engrossed. That is, it's deemed in its proper form. However, when a bill passes both houses of the legislature and it's ordered to enrollment, in enrollment, the bill is again proofread, checked for accuracy, and then delivered to the governor. So that means engrossing and enrolling are two different, separate, distinct processes. Question eight, a bill containing an urgency clause requires only one vote for passage. I did cover this briefly a moment ago, and no, that's false, because there's a vote on the urgency clause, which requires a 2/3 vote, is actually required under Joint Rule 27 to precede the vote on the bill in chief. So in reality, there are actually two votes taken on the floor of the Senate and Assembly for a bill that contains an urgency clause. And remember, the first is on the urgency clause, and the second is on the bill. And so what you'll hear is the presiding officer will actually state, for example, ayes 60, noes 10 on the urgency, ayes 60, noes 10 on the bill. Question nine, senators need a second in order to move a bill just like in the state assembly. And that's false. In the Senate, to vote on a bill in committee only requires the initial motion. However, in the Assembly, a motion and a second are required before a bill can be voted on in the committee. Question 10, bill amendments need a majority vote of the membership of a committee for a committee amendments or a majority vote of the House for floor amendments in order to be properly adopted. And that's actually false. Amendments to a measure can be made by a majority of those present and voting rather than a majority of the full committee or of the entire floor. Question 11 is all measures introduced in the first year of the session must pass out of their house of origin by January the 31st of the second year. That is actually false, and here's why. It is the applicable rule for all bills, but under Joint Rule 56, it doesn't apply to constitutional amendments, and therefore it doesn't apply to all measures. Question 12 is that legislators in either house can add on or change their votes on bills after the roll has been closed. And that's actually false. Now, in the assembly, members can add on or change their votes after a vote has been announced, so long as the final vote is not impacted. The Senate, however, does not allow this, with two exceptions: the president pro tempore and the Republican leader. And again, this is also as long as the final outcome of the bill is not affected by their add-on or vote changes, and that is in Senate Rule 44. Question 13 is an adjournment motion is always in order in the California legislature. And although that is the case under Robert's Rules of Orders, in the California legislature, an adjournment motion is not in order if any bill is on call. For example, Senate Rule 42 applies here. Now, once the call has been lifted and the vote announced, then a motion to adjourn can be made. But if a bill is on call, it's not in order. Question 14, a bill always needs to be read by its title on 3 separate days in each house. That's false because either house may dispense with this constitutional requirement by a 2/3 vote of that particular house. Question 15 is all introduced bills cannot be heard or acted on by a committee or either house until the 31st day after the bill has been introduced. And that's false because the rule does not apply to the budget bill, nor does it apply to special session bills. It says in a regular session. Question 16 is Proposition 54 prohibits any bill from being passed or ultimately becoming a statute unless the bill with any amendments has been printed, distributed to the members, and published on the internet in its final form for at least 72 hours or 3 days before the vote. That's actually false. And that's because the requirement is 72 hours. It does not speak about 3 days or any days for that matter. Question 17 is a special session bill goes into effect on the 90th day after the special session adjourns. That's also false. And that's because the special session statute goes into effect on the 91st day after adjournment of the special session at which that bill was passed. In other words, 90 days have to go by, and therefore on the following day, which would be the 91st day, the bill takes effect. Question 18, there are 5 types of bills that take effect immediately upon their enactment. And that's false. There are actually 4 types. Those are statutes calling elections, statutes providing for a tax levy, statutes providing for appropriations for the usual current expenses of the state, and urgency statutes all go into immediate effect upon their enactment. Question 19 is that the reenactment rule requires all statutes to be reenacted in their original form every decade. And this, of course, is false. Actually, what the reenactment rule in California means is that each section of a statute that's being amended has to be reenacted as amended in its full form. And that's why you see the entire code section in a bill, even if just one word is added or changed or repealed, the whole statute is reenacted with that single amendment. Question 20 is the governor has 2 options when a bill is presented to him or her: either sign the bill or veto the bill. And of course, this is false. There are three options: sign and it goes into law, veto and it does not become law, or allow the bill to become law without the governor's signature on the bill. Question 21. The state constitution authorizes the legislature to divide the state into fish and game districts. Yep, this is actually found in Article 4, Section 20A, provides this power to the legislature. And the final question, question 22 on the California legislative process in this quiz, is that the 4 legislative leaders are required to report to their respective houses the goals and objectives of that house at the very beginning. And then at the close of session, they actually have to report on the progress that their house has made toward achieving those goals and objectives during the past session. And believe it or not, that is true. It's found in Article 4, Section 22 of the California Constitution.